throughout the semester. But our discussion now will focus specifically on an area of law that's referred to as substantive due process. Okay, you have the due process clause up here. In order to explain the idea of substantive due process, I want to begin our discussion with a story called The Lottery. Has anyone ever read the story The Lottery? A couple of you? Okay, good. I may call on you in a minute to chime in. But this is a story that I think illustrates what due process of law means. So the story is like this. You have a small village, okay, and everyone gets very excited all of a sudden. They're saying, you know, we have a big event coming up. The lottery is in June. So what happens? Every family in the town gets a slip of paper, okay? And every family is responsible for dropping a slip of paper into this safe. One of the slips of paper has a little black spot on it, okay? So the family that gets a slip with the black spot on it is chosen, okay? So next, each member of that family gets another slip of paper. They draw it from a safe. And then one of those slips of paper has a spot on it. Okay, so these are very strict rules, right? They're very strict rules. If you have this paper, the spot that's fair, no one's cheating. Okay, so then the husband walks up, he pulls a paper, there's no spot on it. The kids walk up, they draw a paper, there's no spot on it. Then the wife, the mom, walks up, pulls a piece of paper, and she has a spot on her piece of paper. At that moment, everyone in the village starts throwing stones at her and kills her. Whoa, right? You didn't see that one coming. And she's stoned to death. And as she's getting stoned to death, the wife says, "It isn't fair." Scotty, finish it.
It isn't right.
It isn't right. It isn't fair. It isn't right. Scotty, why do you think she was saying it wasn't fair and wasn't right?
I'm going back to middle school.
Why did she? Was there anything unfair about the process?
By a lot. So.
Is there anything unfair? Was there any cheating? Were they rigging it? Was it any? You know, they were drawing pieces of paper. Was there anything unfair about it?
I'm sure without a crime, but again, it's by chance. It's random.
Was there any? So let's see. Where did I finish up last time? Okay, you're up. So, was there anything unfair about this process?
Yeah.
Was there anything, you know, not right about it? Was the process by which people selected this piece of paper with a spot on it? Was there anything, you know, corrupt? Was there anything wrong about it? So, is it okay then to stone the mother to death?
No, inherently.
Why not?
Well, if they're just doing it because they're just doing it, then no. It doesn't seem like any situation would justify that sort of an act. It sounds like that's a regular yearly tradition. So, no.
Okay. What do you think, Lara? Is there anything unfair about this act?
It's substantively wrong, not procedural.
Oh my God, I just love your answer. That was like the perfect answer. You said it's not procedurally wrong, but it's substantively wrong. What do you mean by that?
Well, they followed the right. It was a procedure that was set up, so they followed the procedure that was in place, but that doesn't make the substance of.
What's the difference between substance and procedure, Lara? You're exactly right, but explain what's the difference between substance and procedure?
Well, the procedure is just that they follow the rules, whereas the substance is the matter of those rules.
What word would you describe to say whether something's substantively okay? What word would you use? In fact, I think Scotty said it a minute ago. Robbie, you want to take a stab? What word to describe something that's perhaps substantively not right? What word would you perhaps use?
Fair.
Fair. Bingo. Fair. Exactly right. What did the woman say when she was getting stoned? It's not fair, right? we have, perhaps as humans or otherwise, this innate sense of fairness, right? Perhaps we all know that there's some things that are right and some things that are wrong. We'll disagree at the margins, but I think if I polled, everyone in this room, independently, and I said, do you think it's fair that every year in the summer this village decides to kill a person merely because they drew a piece of paper? I think everyone in this room would say that that's not fair. Is everyone with me? Okay. Now, procedurally, right? Procedurally, they erected a very rigorous process. It was totally fair by process standard. But the substance, like Lara said, the substance of the law is like, what the hell's wrong with them? This does not make any sense. Why in the world is the government putting a woman to death because she drew a piece of paper from a thing, right? What the heck is the purpose of this law? So there are two ways of understanding a law that infringes on a person's freedom, right? There's the procedural dynamic. Did the person have a lawyer? Did they get a jury trial? Were the rules of civil procedure, right? Were the rules of evidence? I mean, you don't think about this, but the various substances you have in your first year classes are aimed at procedural fairness, right? You have rules of civil procedure. You can't admit certain types of evidence. You have to have service of process, right? You have to have a personal jurisdiction. There are various procedural rules to ensure that someone is given a fair shake. But fairness, innately, is not limited to rules of process. There's some sort of underlying question of, is it really fair to throw stones at a woman because she pulled a piece of paper out of a slot? This guy said she committed no crime. There was no actual crime committed by her, but she was then sentenced to death. Okay? So that brings us then to the Due Process Clause of the 14th Amendment. And there's one in the 5th Amendment which is framed almost identically. It says, nor shall any state deprive any person of life, liberty, or property without due process of law. So there's a couple of different ways we can approach this, right? So on the one hand, can the government take someone's life, right? Can the government execute someone? Well, if you read the text of this amendment, the answer is yes. A life can be taken so long as due process of law is afforded. This, by the way, is why I have very difficult arguments with the position that the death penalty is unconstitutional. It says you can take someone's life with due process of law. So the fact that the death penalty is always unconstitutional, that argument is very hard to square with the text of the Constitution. Not that that matters. But you can take a person's life, you can take their property, and you take their liberty, so long as you afford some sort of due process of law. So one way you can read this thing, as long as a person has a hearing, right? As long as a person has a hearing, you can take away whatever you want. So we'll do a case next week called Buck v. Bell. This is a case I want you to study very closely. This is a case involving the state of Virginia sought to sterilize a woman they deemed feeble-minded. She was not feeble-minded in any respect, but they said, we want to sterilize her. This is eugenics. We don't want these incompetent people breeding and passing on their what's called the germplasm, like their basically their bad heredity to their next generation. So they gave her a lawyer, they gave her a hearing, and they complied with every procedural guarantee you can imagine. There was evidence, there was a trial, there was a judge. I mean, it was procedurally sound. Not really. Her lawyer was hired by the state, but it was procedure on paper at least. Her lawyer worked for the eugenics colony, but we'll get there next week. But in theory, at least, right? The law provided for an attorney. There's a trial. There's evidence. All the formalities were there. So the state said, "Listen, we gave her all the due process of law we need, right? So now we're going to go sterilize her and snip her fallopian tubes." Procedurally, without a doubt, on paper at least, it was fair. but was the law substantively fair? Okay. Is there any amount of process that would justify taking away a person's, reproduction? They have to remove her fallopian tubes, right? Or cut them. You'll see in the case next week that the court basically said that the procedure was sufficient. Therefore, the surgery could go forward. So the book describes, and I think they actually do a decent job in this, but it's somewhat of the author's own perspectives of saying that perhaps substantive due process is an oxymoron. The idea that procedure has substance to it is insane. The idea that judges should be questioning the fairness of a law is insane. The court, and this has gone back and forth, has more or less rejected that view. The court has effectively said that courts can not only assess whether the process is fair, but the underlying law itself is fair. Now, on the one hand, you say, well, that's great. Of course, judges should determine what's fair. But then comes the second question. How are judges supposed to know what's fair? Now, a judge can ascertain if procedure was followed. Like, was there a jury? Was the jury properly selected, right? Were the rules of evidence complied with, right? These are the sorts of questions which a judge can figure out. Now, how would a judge review fairness of a law? Now, maybe people say, yeah, the state has a good reason why they want to sterilize incompetent people. Or maybe a judge may say the state has no good reason to limit the number of hours a baker can work. Or maybe the state will say, the court will say, the state has no good reason why married couples should have access to birth control, right? There's no reason why you could ban that. But inherently, there is an issue of whether the judge's wisdom comes in. And the judge is saying, listen, the decision the legislature made in enacting this law, I know better. I know better. They were wrong, right? That is not a good law. So the difficulty of substantive due process is when judges start saying that the legislature made a mistake, that they did not properly consider whether a law was substantively fair or not. And you can imagine that this is controversial. And the reason why it's controversial is you basically have now 5 judges who indeed are not elected, who are arguably using their own sense of right and wrong to second guess the legislature, which is elected. I'm not saying it's always right or always wrong, but this is why the doctrine of substantive due process has been so controversial, doesn't even come close to it. Because we have decisions that have been like Roe v. Wade and Lawrence v. Texas and Obergefell. These are decisions where courts have made something approaching social policy that displaces a decision made by the elected branches. And maybe it's right, maybe it's wrong. We can discuss this for the next month or so. But there has been a significant debate over this topic of whether judges have this sort of authority. Okay. So questions, the introduction. Questions and introduction. No? Okay. And one point which I should have mentioned before, but the phrase due process of law has a very long lineage. Indeed, the phrase due process of law stretches all the way back to 1215 with Magna Carta, the Great Charter. And one of the provisions of Magna Carta was that you could not deprive someone of their life or liberty except by the, quote, law of the land. This is called the law of the land clause. And this was a revolutionary idea. Before Magna Carta, the general presumption was whatever the king said goes, right? The king was the law. I am the law. I'm above the law. But the idea of the law of the land was that there was some sort of law above the king, right? There was a law. And this informed the American experience where we have a constitution which is indeed above the Congress. The Constitution is indeed above the president. The Constitution is indeed above the courts themselves. So that the idea that there's some greater law to apply when you're depriving someone of their liberty. All right, so any questions? Okay. So let's start by talking about the meaning of the word liberty. And perhaps this is what has given this topic so much difficulty. There's this great quotation from Abraham Lincoln, which I like reading. Abraham Lincoln once said, "We all declare for liberty, but in using the same word, we do not all mean the same thing." And Lincoln uses this example. The shepherd drives the wolf from the sheep's throat, for which the sheep thinks the shepherd is a liberator. But the wolf denounces the shepherd as a destroyer of liberty. Think about it for a second, right? Lincoln had a good way with words. That's why he became president. If you're a sheep and you look to the shepherd who's saving you, the shepherd's your liberator. If you're the wolf, you're looking at the shepherd, that's your tormentor. So the idea of liberty is very personal. And depending which perspective you view the question from, you get very different answers. And the case we study today, the Lochner case, I think illustrates that quite well. On the one hand, you have the argument that the workers have a liberty interest, and they can make whatever sort of contracts they want. You have the employer, who also asserts a liberty interest. Who says, if I want my workers to work 60 hours, then they'll work 60 hours. But there's another liberty interest that law students never, ever, ever think of. Is not democracy and the ability to pass the laws through your own government a liberty interest? You never think about this, right? When a court invalidates a law, they're taking away from the representative republic, right? You have the legislature, you have the governor, whatever the process is, enact the law. Is there not a liberty interest in self-determination? Is there not a liberty interest in deciding which laws should govern your people? Is autonomy not a liberty interest? This is the part that law students can't begin to fathom, because maybe most of you don't vote, but maybe you do, hopefully you do, right? But when you vote for someone and that person votes for a law, that's a big deal. We have democracy. So in this respect, when a court steps in to invalidate a law, that's in some respects anti-democratic. Not that it's wrong, right? If there's indeed a constitutional violation, but it's something I want you to think about, that there's also competing interests. I think my allergies are off today. Okay. All right, so any questions about that? So, curiously enough, we begin our discussion of substantive due process not with anything, like a hot button issue, not like with abortion or contraceptives or gay marriage, whatever. We'll get there next week. Our discussion of substantive due process begins with what can be roughly termed economic liberty. That you have a liberty interest in making contracts. So, to begin, we actually discussed this before. You'll recall that when we discussed the slaughterhouse cases, that was a case from New Orleans, where the state said if you want to run a butcher shop, you need to do it in this one location, and any butcher shop outside this one location was shut down. Now, the butchers brought suit, and they asserted that this violates their freedom of contract, that the 14th Amendment's Privileges or Immunities Clause guarantees a right to pursue an honest living, that if you're in a lawful vocation, the state can't criminalize what you're doing merely because they don't like it. Okay? One of the reasons why they thought that the Privileges or Immunities Clause protected this was because you had other acts that came before it, like the Civil Rights Act of 1866 and the Freedmen's Bureau Act, which specifically sought to protect the rights of the freedmen, the freed slaves, to make contracts. One of the ways that slavery was perpetuated after the 13th Amendment was to say that, oh yeah, these Africans, they can't make contracts. And if you can't make contracts, you can't work except for being basically an indentured servant. They couldn't freely engage in the sale of land. The Slaughterhouse Court, though, said no, that the Privileges or Immunities Clause had no meaning, that it merely protected a small subset of federal rights that had no value. But then a funny thing happened, right? There was still this sense that the Constitution protected this right of contract. So the argument shifted. They shifted from arguing that the right to contract was a privilege or immunity, and they shifted down. And now the argument was made that one of the liberty interests protected by the 14th Amendment's Due Process Clause was a liberty of contract. The right of contract, they argued, was protected by the 14th Amendment. So throughout the late 1800s, in a series of decisions, the Supreme Court began to issue decisions recognizing that various business laws and business regulations ran afoul of this right of contract. So one of the first cases from 1877 was called Munn v. Illinois. And the court said in private contracts relating to matters in which the public has no interest, what is reasonable must be ascertained judicially. So that is, in private business contracts, when the state seeks to regulate them, we have this issue of substantive fairness, right? Substantive fairness is decided by the courts. So the courts decide whether, in fact, a business regulation is fair. Again, it's not whether a process was afforded, right? It's not whether they said all butcher shops must shut down and we'll give you a hearing to make sure that your license is renewed, whatever. The process is irrelevant. It's the substantive law itself that is challenged. So after Munn v. Illinois, there were a series of decisions, Mugler against Kansas in 1887, the Railroad Commission case in 1886, the Chicago Railroad versus Minnesota in 1890, Allegayer versus Louisiana in 1897. Each of these decisions started building up the proposition that there was a role for the courts to invalidate laws that they deemed were unfair and intruded on the liberty interest. Okay, John, your hand up?
Yeah, it's not necessarily on this, but how come rights were also put into the due process clause? Or is that just the
What's our rights?
like right to vote?
Ah, okay. So,
I mean, it's what I thought in my head. I'm preaching on that.
okay. So what's interesting, okay, I'll take an easy, I'll come back to right to vote in a minute. But what's interesting is during this time, the Bill of Rights, right, the first 8 amendments, did not yet apply to the states. The process by which the Bill of Rights were extended to the states was through the Due Process Clause. Around the same time, the late 1800s and the early 1900s, this was like a 30-year process. But around the same time that the court started reading the Due Process Clause as protecting the substantive right of contract, they started to consider that maybe the provisions of the Bill of Rights were also these liberty interests. Now, I discussed this with you last time, but the correct approach, and this is actually what Justice Thomas said in the McDonald v. Chicago case, would be to say that the privileges or immunities of citizenship are the Bill of Rights. Right? The provisions of the Bill of Rights were these privileges or immunities. They didn't go that far. Instead, the court said that these various liberty interests include the Bill of Rights. Now, John, to your question about the right to vote, we saw, was it in Giles v. Harris? That was the, what was the other one? The one where the grandfather clause, right?
Yeah.
The right to vote was challenged under the Equal Protection Clause. They said because you're basically making this regime where all these white people could get grandfathered in and these blacks could not. The court upheld it. Totally separate from due process, they upheld this equal protection issue, right? The right to vote was viewed as a political right. This right of contract was viewed as a civil right. There was actually a very strong difference between civil rights and political rights. And believe it or not, political rights were protected much less. This is why you need a specific amendment, the 15th, to guarantee the right to vote based on no race. And then you need the 19th Amendment to give women the right to vote based on gender, right? Political rights were viewed very differently. So the 14th Amendment was viewed in terms of protecting civil rights.
I'd just like to settle liberty interest in that political right. Is that how you would argue it? If you were on the opposing side? That is
Well,
liberty interest
I mean, look, so they took the case to the Supreme Court, the Giles case, right? And the courts laughed it away. So even something like a poll tax, right? That wasn't really eliminated until an amendment was the 25th or 26th Amendment. They didn't get rid of the poll tax until decades later. So the short answer is those sorts of voting rights were considered separate from what the 14th Amendment protected. I mean, and one easy way of thinking about it, excuse me, if the 14th Amendment actually guaranteed the right to vote, why do you need the 15th Amendment? Right?
Yeah.
But yeah, good question. Any questions so far? But John's right. The initial, right? The initial cases concerned whether liberty of contract was protected. You didn't really have many cases involving free speech or perhaps freedom of religion. It's all about liberty of contract. Okay. Now, at the same time, and I want to give you this historical background because it's important. At the same time that these cases were coming up, government was changing radically. The idea that government, and it was only the state government, there really was no federal government, but the idea that the state government would regulate businesses was unheard of. Okay? It was frankly unheard of. For the most part, labor conditions, wages, how much people were paid was all a matter of contract between party A and party B, between the employer and the employee. This was all. But in the late 1800s and the early 1900s, a movement began, what was often dubbed the progressive movement. Now, the progressive movement is a broad umbrella, and I'm only going to focus on a small aspect of it. But the general idea of the progressive movement was that there were serious problems in our society that would be cured by government intervention. And maybe the most famous example, which I'm sure you studied, is a book by Upton Sinclair called The Jungle. Okay, this was a so-called muckraker. This guy wrote a book about how the conditions, I think it was the Chicago meatpacking industry, was absolutely filthy. And people said, we need to have a government regulations to improve the conditions of this. And then we have laws affecting, pure food and drug, laws affecting health and safety. And soon, eyes turned to laws affecting labor conditions. Dan?
Wasn't this in a general response to the Industrial Revolution, which
Yes.
the country was really unprepared for?
Yes. Okay. Yes. With the rise of the Industrial Revolution, workers moved away from working on the farm, working close to home. You now have these company towns, you have the coal mines, and there was a very strong sense that the arm of government was necessary to prevent people from being exploited and taken advantage of. So what's interesting is that as legislatures became captured by progressives, one of the conservative institutions that prevented them from taking over was indeed the courts. Because even if a legislature managed to pass a progressive piece of legislation, and the governor signs it, whatever it happens to be, the mayor, the governor, whatever it is, excuse me, if a court steps in and starts to consider the fairness of the legislation, courts can halt the progress of these various progressive laws. Okay? And I give you this history not just to, bore you with history, but I give you this history to explain why the Lochner case and the doctrine of substantive due process had become so reviled. I think there's a note in your book, which I'm not too crazy about, but it's there, that says Lochner is an example of how not to decide cases. You read that, right? Virtually every law professor in the country, and I say this with candor, except for myself and a few others, will tell you that Lochner is the worst case ever, that Lochner is as bad as Dred Scott and Plessy against Ferguson and Korematsu. Indeed, there's articles saying, what are the worst Supreme Court cases of all time? So you have Dred Scott, you have Plessy, you have Korematsu, you have Lochner. What? A Baker case? This is as bad as Dred Scott, with his awful opinion from Tawney? I mean, how could this be? So again, what you're hearing here will not be what you hear in most law school classes, but I will give you an alternate perspective, which is why I gave you the David Bernstein article. David was my ConLaw professor, which it rubbed off on me, I guess. And he came here about a month or two ago, and hopefully some of you saw him. The reason why Lochner was viewed as so evil was because it got in the way of progressive legislation. Okay? The reason why Lochner was viewed as so evil was it got in the way of progressive legislation. There are many instances where substantive due process gets in the way of laws. For example, substantive due process declared laws about birth control, it invalidated laws about abortion, invalidated laws about gay marriage. There have been lots of instances where courts second-guess the wisdom of legislatures, right? Where courts say, you can't ban contraceptives and you can't ban abortion, right? Judges very often step in and substitute their wisdom for that of the crowds. What makes this case different is the sorts of laws being invalidated. Rather than invalidating laws that most law professors like, such as laws about abortion, the laws they dislike, like laws about abortion, birth control, here they're invalidating labor regulations. They're the same thing, okay? A court invalidating a labor regulation and a court invalidating an abortion law, fundamentally, right, it's the same process. They're saying the Constitution prohibits the legislature from doing this. Now, some people may really hate abortion laws and some people may really hate labor laws. They usually don't overlap. So the reason why Lochner has become so reviled and hated and despised, and I'm sure if you go to any of the law professors, oh my God, Lochner, that's evil, is because it gets in the way of progressive legislation. And I can't say it any more simply than that. It puts to a halt laws that progressives like. And we'll study today of how this so-called Lochner era, a term I don't particularly like because it doesn't really describe anything, but cases during the early 20th century, the courts often use a due process clause to invalidate, excuse me, a little congestion still, to invalidate various labor laws. And it took the revolution of 1936, yes, 1936 again, and Franklin Roosevelt, to put a halt to this idea of substantive due process. This was the West Coast Hotel v. Parrish case. And over the next number of years, scholars buried substantive due process. They killed it. They said, we can't do this. Judges should not be in the business of second-guessing legislatures. Until 1967, with Griswold against Connecticut, where the court said that Connecticut can't ban birth control for married couples. Why? Wasn't fair. So there's this inherent tension. If you indeed think that Lochner is the most evil thing ever, a similar treatment should be applied to cases like Roe and Griswold and Lawrence. Now, the court developed a lengthy doctrine saying, well, abortion is a fundamental right, and it's important, whereas economic liberty is not. That's a matter of judicial creation. There's no actual law. 14th Amendment says nothing about fundamental rights, which rights are more important. It's just liberty. So once a court says X is a liberty interest, right, the court's still saying they think that's what's important. And they can then separate different types of rights. So I give you that history because it's important to have a balance, because virtually every law professor has accepted the orthodoxy, which I think is not supported by history, but it's become a necessity to believe in certain circles. Okay. So let's move on to Lochner versus City of New York. I'm sorry, Lochner versus State of New York. Excuse me. I had you read the David Bernstein piece because David, who again was my ConLaw professor, is probably the leading expert in the world on Lochner. Very few people know anything more than him, but he's up there. So the case, the Lochner case, is interesting. All right, so let's see. Katie, I've been talking enough. What was the law, excuse me, that New York passed?
Passed a law that said that you could work 160 hours a week, about 10 hours a day.
Very good. Okay. Very good. Katie, why did New York pass this law?
They think it was for sanitary reasons. They didn't want to have extra stuff in it for people who were working constantly.
Very good. Okay, so this was a quintessential progressive law, limiting the maximum number of hours a person can work a week, right? We don't see these sorts of laws too much anymore, although you do indirectly, because under most states, if you work over a certain number of hours, you're entitled to overtime, assuming you're not a manager. Managers and lawyers don't get those sorts of things. If you guys have a 60-hour work week, you're not working hard enough. Oh, you think I'm joking? As lawyers, 60 weeks, that's actually pretty mild. 60 hours a week. Okay, so why was this law enacted? Okay, so the history of this is actually very interesting. The Lochners were actually immigrants. They were immigrant bakers who established a bakery in upstate New York. Here's some photos of Joseph Lochner and his family. Here's some photographs of the bakers working here. By the way, I'm sure things don't look quite as clean as you're used to in a bakery. This was also 1900. Sanitary standards weren't very good back then. I don't think people even knew to wash hands. You didn't do that. There wasn't like, antiseptic soap. That wasn't a thing yet. They hadn't quite figured that part of baking out. Here's another picture of the bakery. Okay, and this is actually the cover of David's book. And this was his loving, but it's Justice Rufus Peckham wrote the majority opinion, knocking out Oliver Wendell Holmes in the dissent. And there's Joseph Lochner cheering on the crowd. I never liked the cover, but David did, so I told him. And I did some digging with the Utica Historical Society, and actually I discovered this picture of Lochner's bakery. It was actually an advertisement used. If you go to my office, you'll see it's hanging above my desk. And it says, Lochner's, one of the oldest, most reliable bakeries in New York. We pride ourselves on uniformity, purity, and cleanliness. So apparently the baker thought that they were clean enough. Okay? So I'll keep this one up here. So why was this law passed? Now you may say, on the one hand, it's unfair for a manager of a bakery to force his workers to work more than 60 hours, right? I mean, that's tiring. It's really exhausting. It's unfair that he should be making people work that many hours. Okay. Ashley, was anyone being forced to work more than 60 hours a week? Under the 13th Amendment, can someone be forced to work 60 hours a week? So who was actually complaining in this case? Who actually was affected by this case? Who actually, who was being hurt by this case? Well, were they being compensated enough, though? What maybe would the workers have wanted? Well, not just higher wages. What may they wanted? Let me ask you this question, Ashley. You're. By the way, these are mostly poor immigrants. This is actually a field dominated by immigrants, right? You're a poor immigrant, right? And you used to work 80 hours a week to support your family, right? You just got off the boat. The state comes and says you can only work 60 hours now. Your wage didn't just increase. You just lost 20 hours of income a week. So who do you think was actually most affected by this law? The workers. Yes, indeed, this case arose because Lochner's workers wanted to work more than 60 hours. Right? You may think, oh my God, who would ever want to work that many hours? If you need to support your family, you're going to work as many hours as you damn well can. Right? I mean, this is not a very difficult concept maybe for people in this room, but if you're dead broke, you have 24 hours in the day, you're going to try and work as many of those hours as you can. I mean, we'll get to the sanitation issues in a few minutes, but you want to work more. So this case actually arose not because Lochner was some sort of slave master. His workers actually want to work more of these number of hours. Now, the history of the case is actually much more interesting than this, right? So, Luis, we know that there were probably some people in the New York legislature who passed this law because they wanted to promote the health and safety of bread, right? Who else in New York do you think favored this sort of law? Which other businesses? What other businesses do you think would support a law limiting Joseph Lochner's workforce? Well, who do you think would stand to gain from this law limiting Lochner's workforce? What kind of bakeries do you think would most benefit from competing with poor Joseph Lochner with this little, shoddy bakery with 5 people working there? Big bakeries. Follow me here, guys, right? If you're Joseph Lochner, right, you got this small, crappy bakery in upstate New York. You got 4 or 5 guys working in there. These are, again, almost all going to be poor immigrants, and they're basically getting, very low wages. If the state says you can only work 60 hours a week, Lochner then needs to hire more people. He may not be able to afford to do that. He can only maybe afford to hire a few people. Maybe he doesn't even know other people. But if you're a big bakery, you have no problem hiring more people because you can afford it. And oh, by the way, you have better machinery. Yes, making bread back then was a very intensive process, but there were machines to actually, the best thing to slice bread, right? There were machines to cut up bread. This law was backed in large measure by the bigger bakeries who could try and put Lochner out of business. This is actually counterintuitive. People think, oh, businesses hate regulations. No, they don't. What'd you say? You said it.
It's a regulatory capture.
What's regulatory capture?
That's when your legislature, your large businesses work together to squeeze out the middleman with burdensome regulations that only the big guys can comply with.
So what's going on here is that the larger businesses want these sorts of regulations because they can absorb the costs, but the smaller competitors cannot absorb the costs. Right? This is not a mystery. Businesses love red tape because they have lawyers who can help navigate around it, whereas a smaller business can't possibly. So this law was backed by the larger bakers who knew this would put out competition in business. Imagine that, right? Trying to get the legislature to pass a law to put your competitors out of business. That's awesome, right? Who wouldn't want to do that? This is actually a process. Scotty used the phrase regulatory capture, which is correct. There's actually a phrase for this. It's called rent seeking. This is a little bit of law and economics if you haven't gotten this before. But rent seeking, a rent is a benefit you get from the government. It's not just what you pay for your apartment. Rent seeking is the idea that you can lobby the government to get laws that help promote your business and to help your business out. So what's going on here is the bigger bakeries want to put Joseph Lochner out of business so that they lobby and they push for this sort of law. And that's what's going on here. And in fact, the majority opinion recognizes that. We'll discuss that later. Right? But who else favored laws limiting the number of hours you can work? Who else? The answer is labor unions, right? Labor unions try to make working conditions better for the workers for a host of reasons. One of the reasons why is it makes if someone's more difficult to employ, it makes labor union workers more attractive because they have training and stuff. These are poor people, who have no training. They're just trying to scrap a living by. So this law was backed by bigger bakeries, it was backed by unions, it was backed by a lot of different groups. So there were indeed, for sure, health and safety motivations going on. But this law was really, I think, geared towards this sort of economic protectionism. So I think a minute ago, Katie said, well, why can't they raise their wages? Notice this was not a minimum wage law. It in no way compensated the workers for having to work fewer hours. It wasn't a health and safety law. It didn't say you need to have a clean kitchen, right? It didn't say you have to have clean surfaces. All it did was put a limit on the number of hours that can be worked. So, did this law, in fact, promote the public safety and public welfare? Or is this merely a law aimed at protectionism, that is, protecting the larger bakers, right? Who was actually behind this law? So to explain this concept, there's a provision I think I mentioned before. I think I did it, Samuel. The Baptists and the bootleggers. Remember this? Want to tell me what that is? I think you're a resident bootlegger.
Yeah, that was the concept that the Baptists had it for their moral reasons that they wanted prohibition. The bootleggers wanted it because if there's no legal booze, then they can make a whole lot of money.
Right.
Selling it.
Right. So in any sort of regulatory situation, different groups support a law. So there are some people support our law because they're motives, like they're Baptists. They don't want alcohol. Alcohol is evil. But then there are the bootleggers. They like prohibition because once there's no alcohol on the shelves, they can make moonshine like Samuel and sell it for a profit, right? Okay. So who's here? The Baptists and bootleggers. So for certainly you have the Baptists, right? These are the progressives who want to help the workers. They want to make working conditions better. They want to make food safer. They want to help people. So there's definitely people with good motivations behind this. Who are the bootleggers, right? Who are the bootleggers? The bigger bakeries want to put their competition out of business. The big unionized bakeries want to put Joseph Lochner out of business using the arm of the state. So this is classic rent-seeking legislation, right? This is classic legislation where, for the most part, this is motivated by unions and bakers, but I'm sure there's some, Baptists in there, they want to help people. Although it's hard to imagine a law limiting hours but not touching wages or sanitary conditions actually helps people. This law, at its base, simply makes it harder for people to work and offers no substitute. Just to make the point even clearer, if you can't work 60 hours a week in one place, the same worker can go across the street to a different bakery and work another 20 hours there. The law doesn't actually limit the total number of hours you can work a week. It doesn't even accomplish what it seeks out to accomplish. It just says you can't work at a single bakery for 60 hours, which is what it's trying to do, punish bakers with small workforces. So I'm going to get that background. It's a little economics lesson, but I think it helps explain this. Yes, sir?
I just have a question about the particular, if you know the particular facts of how this case, because it says it's an indictment.
Oh, it was a criminal case. Yeah.
Yeah, so it says that Lochner got indicted for
Yeah.
I guess allowing his work.
Well, it was a test case, right? Lochner deliberately let his workers work with 60 hours to challenge us in court. This was a deliberate test case. And actually, one of the ironies of this case, David writes about this in his article, is that Lochner was one of the people who helped develop this law in the first place. But he had a change of heart later in life when he ran his own business, so he decided to challenge it. But also the lawyer who represented Lochner was also involved in drafting this law, and he had a change of heart. Law's funny like that. But it was a criminal indictment. This was not a civil action. This was a criminal indictment. It was a fine for employing your workers more than 10 hours a day. I don't know if there was jail time possible, but I know there was definitely a fine as possible. All right.
Sorry.
Yeah.
Was this also limited to only bakeries?
Yes, only bakeries.
Okay.
And so no other profession had this limit. Yes.
Couldn't you argue that protectionism, like geared towards large businesses, is for public welfare?
Oh, what a good argument.
People
Is
make that for
protectionism a legitimate governmental interest? Why would you say protectionism is a legitimate governmental interest?
Well, I'm saying in this particular instance where we're talking about, you could say that the large corporations are able to hire more people. They're able to employ better standards. They have better machinery licenses, better resources available.
Oh, so screw the small business, right?
I'm saying that.
So I was gonna get to this point probably next class, but I'll do it now. It's a very good question. There was a case a number of years ago where the state of it was Tennessee, passed a law saying that in order to sell a casket, right, a box which you're buried in, right, basically a wood box. So in order to sell a casket, you have to be a licensed mortician. Okay. Now, are there any morticians in the room? To be a mortician is very difficult. You have to do like 6 years of training. There's an apprenticeship. You have to learn how to embalm a body, right? I mean, there's some really difficult things to be a mortician. It's not just you can't just show up and do it. So there was some. I think it was a church that decided to start selling caskets to its members to save the money because that stuff's expensive. You ever have to buy a casket on short notice? They're gonna rip you off, right? So a church said, you know what? We're gonna just buy a lot of these in bulk, and we'll just sell them at cost to our members. Sounds like an awesome idea, right? Sounds like a good idea. The state stepped in and said, if you guys sell caskets because you're not a licensed mortician, we're going to shut you down. What is a state's interest? Protecting the mortician business, right? Protecting the mortician business. And to Randall's question, a number of courts have held that protectionism, the idea of protecting certain business and industries, is a legitimate basis on which to uphold the law, right? That the state is choosing to favor this group of businesses over that group, that's legitimate. So your intuition perhaps was right on target. Courts have held that. Other courts have not. There's actually some of a split on this issue.
Can we follow our monopolies constitutional?
What do you mean constitutional?
I was like,
Well, the state can grant a monopoly, right? Which is effectively what they're doing. They're saying that only people who are morticians can sell caskets in wooden boxes, right? So what they're effectively saying is that the courts can't second guess the wisdom. Although in this case, the opinion was actually authored by the judge I clerked for. He said that protectionism is not a legitimate rational basis to act upon, but that is something that's outlined. That's what I have.
Why didn't we talk about this?
Oh, I'll get there later. I'll get there later. I'm not bothering the screen up. I'll get there later, I promise.
And also, the David Bernstein article, he was speaking of 3 conditions that we should follow. Should we follow those 3 conditions, or that's just his opinion? Like to determine if the government is the correct decision.
Well, listen to what I say. We'll talk about it later. We'll get there later. Yeah. And I'll never stop giving David enough flack about this. He gave me an A- in ConLaw. I remind him of this all the time. It's like, you gave me an A-, now look at me. So he's like, you deserved it. Maybe it is. By the way, and the reason why I got an A- is because he had multiple choice, and I'm awful at multiple choice. This is why I don't ever give him multiple choice. I'm awful at them. I actually did the math. When there was a multiple choice exam, I had like a full grade lower than for essay. I was awful at them, which is why I'll never give you guys a multiple choice question. I hate them. Can't write them, can't take them. So that's why I got an A- in ConLaw with this class. Still mad about that one. That one still stings. Actually, I got a B plus in ConLaw 1 and A minus in ConLaw 2. The B plus was all multiple choice. There it is. Obviously, I didn't know what I was talking about. So let's move on to the opinion itself. So Rebecca, let's move back onto track. Rebecca, tell me, please, what is the police power? Loud, I can't hear you. I'm sorry. What are the items that the state can regulate under their police power? There are a few major heads that the state can regulate. Mm-hmm. Good. That, exactly, right? The police power. The state has the police power to regulate the excuse me, the safety, the health, the morals, and the general welfare of the people. Okay. The state has the power to regulate the safety, health, morals, and general welfare. It's important to distinguish this. The federal government lacks the police power. The federal government cannot do whatever they want to regulate health and safety. They can only do that which they have the enumerated power to do. Of course, as you know, the Commerce Clause has been read to be so broad, it effectively amounts to a police power. But the states do have a virtually unlimited police power. They can regulate almost anything they want. Now, the exception to this is the 14th Amendment. The 14th Amendment operates directly upon the states. And the 14th Amendment says you cannot deprive someone of equal protection. You cannot deny them of a liberty interest or that due process of law. So what the 14th Amendment does is it chips into the Supreme Court's, the 14th Amendment chips into the state's police power. And as the court has interpreted the 14th Amendment, the courts get to decide whether a state action comports with the 14th Amendment. So effectively what the 14th Amendment does under our current jurisprudence is it gives the Supreme Court a license to second guess and challenge the legislative enactment of the state. Okay, everyone get with that so far. So then the question becomes, is this New York law? Okay. Is this New York law indeed within the police power? Right? So Tariq, is a law limiting the number of hours that someone can work within the general police power of the state? That's my next question. You're one question ahead of me. You're right on track. Answer this question first. Is the state regulation of labor conditions within their police power? Is a regulation of a bakery within the power of the state to guard the safety and health of workers? Okay, so it's within the police power. Now you're going to answer my second question. Is that enough to simply say it's in the police power, let's go home? That ended the inquiry. What's the next step of the inquiry? Bingo. Okay. So what the court says is, yeah, fine, right? Regulating health and safety of the workers, police power. But it must comport with the 14th Amendment. And the court has held on many occasions before that one of the liberty interests protected by the 14th Amendment is this right of contract. Okay? Is this right of contract? So what the court says is that the state can only prohibit this right of contract if it has, quote, a legitimate exercise of its police power. Okay? They could only regulate these sorts of contracts. That is, I want to work 80 hours a week. They can only regulate that contract if it's a legitimate exercise of the police power. Jacob, who determines whether it's a legitimate exercise of the police power? Courts. And where do the courts get the license to make that determination of legitimacy? The 14th Amendment. Exactly. So the courts say, the way I read the 14th Amendment is that it gives us the right to determine whether this state action is legitimate, or to use Robin's word from a few minutes ago, whether it's fair, right? Is this a fair law? Not procedurally, right? Lochner got a trial. He had a criminal trial. There was a jury. There's no problem there. The question is whether the law was substantively fair. Whether the law was substantively fair. And indeed, the court says, is this a, quote, fair, reasonable, and appropriate exercise of the police power? Yes. Is it fair, reasonable, and appropriate exercise of the police power? Or is it unreasonable, unnecessary, and arbitrary interference with the right of liberty of contract? Okay? So the court is basically judging, is this law reasonable? Is this law fair? Okay? So Catherine, what does the court say? The majority opinion by Justice Peckham. Here, I'll show you his cartoon character, and from the cover, you know who wins this. You know who wins this round. He didn't win the match, but perhaps he won this round. What does Justice Peckham say?
He says that it is unreasonable and unfair that
Good. Why does he say this law is not reasonable?
He said that, I guess in Substantive, he said that legislation can do this, how far will it go? And so.
Good. Very good. So the argument here, and you can characterize it in different ways, but the argument here is what may be called a slippery slope argument. I think Catherine characterized it well. If the state can do this, they can regulate virtually every aspect of labor. Now, again, today, in the year 2016, every aspect of everything you ever do is regulated by someone, right? You wake up, you take a breath, you just emitted, some sort of toxic pollutant, right? You have a puddle in your backyard, it's now water of the United States. Every aspect of everything you do is subject to some sort of bureaucrat. I mean, it's good or bad, it's a fact that we live with, right? That was not the case in 1900 or 1905 when this case was decided. It was indeed a novel idea that the government can come between a baker and his boss to decide how many hours they could work. Right? It was a novel idea. So the court writes that there is no reasonable ground for interfering with his liberty of contract. None. They said, we've upheld regulations in other dangerous professions. So, for example, mining, limiting the number of hours someone can work in a coal mine, the court upheld that law. But there's no allegation that bakers are a particularly dangerous class. Right? Again, the court is making a substantive judgment about how safe or unsafe different professions are. Mining, unsafe. Bakers, safe. The court also makes another point, Catherine E. Is there any argument about why the bakers and Mr. Lochner can't come to their own terms? Like, well, why can't they just negotiate this themselves? What does the majority say about that? Good.
And then the court will say there is, and the bakers should be able to decide.
Okay, good. So you said something very good. Why would the state argue this unequal bargaining power? What's the argument there?
Well, they would say that the employees, if they're paying their migrant, or like immigrants coming in and they kind of are desperate, they don't really have that kind of bargaining power with the employer. The employer is going to take advantage of that.
Okay, very good. So the general argument is, and this is a general argument in favor of unions, generally speaking, is that a single employee does not have the leverage necessary in order to negotiate with his boss, right? Because what if one worker says, you know, Mr. Lochner, I want a raise. Lochner says, okay, you're fired. Next immigrant come in and work for me. Okay. However, if there's some sort of perhaps a union, or if the state steps and says, you know what, you're going to pay these workers a minimum wage, Lochner then can't fire everyone. Or if there's a law, he's indeed obligated. So the state's perspective is that these workers really don't have bargaining power. Now, Catherine, what does the court say? What does the court say about their bargaining power and their capacity to negotiate contracts?
Well, they're looking at the right of contract and it is a employer, so the state doesn't have a reason to step in and regulate that.
Okay, very good. Very good. The court says there is no contention that bakers as a class are not equal in intelligence, right? They're saying, look, these bakers, maybe they're immigrants, whatever, but they're still people and they can make their own agreements, right? We have a very paternalistic sense among us today, maybe some of us more than others, but we have a paternalistic sense that people can't make good decisions for themselves. That was contrary to long-standing thought, saying, you know what? Let people make their own mistakes. If someone wants to work 60 hours a week for low wages, sucks for them. But let them make their own mistake. The government doesn't need to be their nanny. These were different schools of thought. This progressive thing saying we need to care for people, and this sort of I'll say libertarian, although that wasn't really a word used back then, a libertarian sense of let people make their own mistakes. Indeed, these were different theories of economics. The question becomes, though, should the court be in the position of resolving sort of dispute? Does the 14th Amendment actually embrace this idea of liberty of contract that gives the courts the license to make this sort of determination? Or is the 14th Amendment silent as to liberty of contract, in which case, if the majority of the legislature wants to make this sort of law, well, it's not for the courts to stop them. Okay. The court goes on to discuss the fact that this law has nothing to do with health. It doesn't have any minimum sanitary conditions. It doesn't say I have to keep your kitchen clean or keep your ovens clean. It's only about hours. That's all it does. The court says clean and wholesome bread does not depend on whether a baker works 10 hours or 60 hours a week. You want to raise your hand?
Sorry, I'm sorry.
That's okay. The reason why is it gives me a second to actually adjust and switch from lecturing
No,
to calling.
sorry, you just said something. It's like, no, it really does. Like, if you're working a lot of hours, it will affect your performance. It will affect whether or not the bread is dirty. You know, if you're exhausted and can't work. Sorry, go ahead.
No, I think John, your point's well made, and this is indeed one of the points made by the dissent, right? The majority opinion here is necessarily offering their own supposition of how things work. Is there any evidence for this? Well, maybe, maybe not. But the arguments are what the court thinks is the right way of viewing these sorts of labor conditions. Okay? So for this reason, the court finds, the majority, that the labor law does not fit. Okay? Now, Tariq jumped ahead. But the idea of scrutiny, as we discussed it, didn't exist yet. Now, I discussed with terms of equal protection. Okay, I discussed with equal protection that you have these 3 levels of scrutiny, right? There's 3 levels of scrutiny. To confuse you, for due process, there are also 2 tiers of scrutiny. However, they're different. Okay. Okay. I'll give you a preview. But you remember for equal protection, you had rational basis, you had intermediate, and you had strict scrutiny. Okay. For due process, okay, you have basically two tiers, two and maybe three. You have rational basis and you have strict scrutiny. Now, with equal protection, okay, what triggers it? What kind of classification? So if it's a racial classification, it's strict. If it's gender, you go for intermediate. And rational basis is basically everything else. How do you decide scrutiny for purposes of due process? The question is the right fundamental? The right's fundamental, scrutiny. Non-fundamental, it's not. I may be asking, Josh, how do you know if a right's fundamental? We'll get there, right? We'll get there. The court basically makes it up. But to cut to the chase. But what we have here, right? What we have here is the majority opinion is applying something that resembles strict scrutiny. The majority opinion is applying something that resembles strict scrutiny. Again, that word wasn't used. The lexicon didn't even have it. Okay. So the court says the act must have a more direct relation as a means to the end, and the end itself must be appropriate and legitimate before an act can be held valid. This is the question of scrutiny, of fit. They're saying you need to have a very close fit between the means and the end. This is what we've talked about before. If the state wants to improve safety, they can pass a sanitation law. They can pass a law regarding cleaning standards. This law is not directly related to safety. Now, to John's point before, maybe it's true that the number of hours you work makes you more sloppy and you're going to drop the bread and whatever else, right? But the court says that relationship is not tight enough, that they were actually trying to go after health and safety. They have gone after health and safety and not merely limited the number of hours. All right. Now you may be saying, well, wow, that's really strict. Well, what they're actually doing is giving a very rigorous review. Now, what's motivating this review? Yeah, so this is where the court gives away the history I discussed at the outset of class. Justice Peckham writes, "It is impossible for us to shut our eyes to the fact that many of the laws of this character, while passed under what is claimed to be the public power for protecting the public, in reality are passed from other motives." Everyone see that in the notes, right? He's saying, look, we know what's going on here. All these progressives are saying we're passing this law for health and safety, but these laws are enacted for other motives. This is a Baptist and bootlegger argument, right? He says, we are justified in saying so when on the face of the law it appears that public health bears but the most remote relationship. He's saying this law is not about public health. This law is about special interests. This law is about protecting competition. This law is about protectionism. Okay? He's saying this is so simple as a matter of economics, and I think it is. I mean, historically, he's right. Whether the court should be making these decisions is a different story, but as a matter of history, these were laws meant to put out of business competitors. They weren't actually aimed at health and safety. I mean, maybe they did incidentally, but that wasn't their purpose. And when you apply this sort of strict scrutiny, where it's finding a direct relationship between the means and the ends, this is what happens. The court says, this is not a health law. The real purpose of this law was to regulate the number of hours. That's it. And that, the court says, is not legitimate. So that's the worst opinion in the history of mankind, or close to it. Again, I mean, it does, you don't have to agree with it. I mean, and I don't particularly agree with the majority opinion either. I think the Justice Harlan dissent is probably better. But this decision is reviled because it stood for the proposition that progressives couldn't pass the laws they wanted to pass. And for that reason, it's held alongside Japanese internment and segregated train cars and the Dred Scott decision. Questions on the majority opinion? Where effectively they're applying something that approaches strict scrutiny for liberty of contract. Questions on the majority? Yeah, John?
Do you think that the law from the state had added some superficial help to the public?
Oh, what a good question.
Statutes with it, so like, it seems like the problems were strategic one of how the law was actually passed as opposed to.
So if it said, you know, keeping your oven at a certain number of degrees and keeping your desk clean, whatever else.
Sweep the floors every few hours.
Now, John, let me ask you a question to probe that. In order for the state to pass that law, what else would the state have to do? How would the state verify that you're indeed sweeping the floor and cleaning your counters?
Safety inspection.
Were there safety inspectors in New York in 1905? No. So it's interesting about your question. In order for the state to actually pass sorts of health and safety regulations, you need to create an entire apparatus to investigate and monitor, right? That's expensive for the state. The state didn't necessarily want to do that. That's why this law, which is focused only on hours, is so clearly and transparently designed as an anti-competitive law, right? The fact they didn't even bother establishing a safety board suggests they didn't actually care about this stuff. That's why the majority says, we know what's going on here, right? That's why it's here. The counter argument to that, right? The flip side to that is saying the legislature doesn't have to act all at once. They can move incrementally. Start with hours, and then in a couple of years, maybe make a safety board and then have inspecting. So generally speaking, governments don't have to act perfectly at once. But when you apply this sort of really strict, rigid scrutiny, you demand perfection. And if it falls short of that, the courts find it's invalid. Any other questions? The majority opinion, Lochner.
I think they're once again kind of lifting up the hood of what the legislature is trying to do behind the law and being like, hey, we're not doing that, not cool.
You know, like in Wizard of Oz, don't look at the man behind the curtain,
So
right?
that's the same kind of.
They're calling out a pretext.
Yeah.
It's pretextual, saying we know what's actually going on here. You're not actually trying to help safety. You're simply trying to protect bigger bakers. And I mean, that's exactly what this law is about. I mean, if you read David's book, which I encourage, the history here is pretty damning. I mean, this was not a safety law. Maybe there are others, but this wasn't it. Questions? Yes, sir.
Just about the precedent of this case, even though it's supposedly one of the worst cases ever decided, it seems like it's still relatively good law today.
No, oh my, no, it's not. No.
Because it just seems like it sends.
It's not good law.
That you couldn't restrict their hours unless you met these.
No, I mean, we'll get there in about 15 minutes, but this case is no longer good law.
Okay.
The decisions of the New Deal and cases thereafter buried Lochner deep. That's why David's book was called Rehabilitating Lochner, trying to rehabilitate it.
Okay.
No, this case is not good law. Actually, David's license plate in Virginia is actually the citation to the Supreme Court reporter for the Lochner case. It's like, it was like 75 US, whatever. That's his license plate. I have another friend in California who has the same license plate, so don't laugh. Yeah, I saw. If it makes you feel better, it's a minivan for his 4 kids or 3 kids. David's a good friend. All right. Yeah. Texas's are too expensive. I used to have one, but not anymore. Texas's, the vanity plates are really expensive, like $200 a year. That's it. In most states, it's like $25, and you keep it forever.
That is like 250.
Yeah, no, they're really expensive right now. So I have a general one. I had a friend who actually litigated the Heller case, the Second Amendment case, and he wanted that to be his license plate, but it was too many digits, wouldn't fit. Because now we're in 3 digits to the U.S. report instead of 2, so he couldn't do it. You guys are not on my level. Yeah. Any other questions? The majority.
Text up to 7 digits on that.
Yeah. So basically, it would be 3, 2, and 3. It would have been 8 digits for Virginia. It's too long. All right. So, Austin, let's talk about Justice Harlan. So, it was a 5-4 decision, right? So there were 5 in the majority, and there were 4 in dissent. The most famous dissent, and the one which everyone talks about, is that of the guy on the floor, Justice Oliver Wendell Holmes Jr. It's revered in many circles as the greatest dissent ever. I'm not exaggerating. I don't know that that is a warranted conclusion, but that is how it is viewed. Holmes was alone. Holmes had no one else join him. The dissent that had 2 others, for 3 people total, was that of Justice Harlan. Again, Justice Harlan was our dissenter in Plessy, and our dissenter in Berea College, and our dissenter in a number of other cases where he took a very forward-looking view of the law. So, Austin, tell me, sir, please, what was Justice Harlan's approach to this case?
He says that if the end was a proper police power, and if the means were not plainly and probably unauthorized by law, then the court should not interfere.
Excellent. So whereas majority applies something approaching strict scrutiny, again, it wasn't called that. The phrase didn't exist, so it's not correct to say it's strict scrutiny, but it approaches it. The dissent applies something that is reminiscent of what we may know as a rational basis review. So it's interesting, Justice Harlan agrees, and this is actually very important. So when you ask me, is Lochner good law, I'll give you a slight caveat. Justice Harlan agrees that the 14th Amendment protects the right of contract. Justice Harlan agrees the 14th Amendment guarantees the right of contract. The difference then between the majority and Justice Harlan is that Justice Harlan wouldn't be so strict about it. He doesn't require a direct relationship between the means and the ends. He says as long as there's some sort of reasonable basis between what the government's doing and how it affects liberty of contract, good enough for me. It's not for the courts to be so strict in how they review it. So Harlan would say, well, you know, like John said, maybe people who work too many hours will make dirty bread. Maybe they'll be sleepy. Maybe in different countries around the world, there are different standards for working, right? Who are we to say that 10 is too much? What about 18? What about 20, right? Is there some limit where the government can put a correct number of hours? So he says, and this is actually a famous formulation, we're not going to invalidate a law unless, quote, it's beyond question, plainly and palpably in excess of legislative power. We will not invalidate it unless it's plainly and palpably in excess of legislative power. What does that mean? Well, think of Obamacare with John Roberts, right? Unless, like, you know, I'm going to bend over backwards every which way I can to find a way to uphold the law. And if I can find some reason why it's valid, you know, that people who work too much make dirty bread, well, then I'm going to uphold it. Okay. The burden of proof rests with the baker. So if you notice, the majority opinion put the burden of proof on the state, right? The state had to prove why this law is on the challengers. They have to prove why the law is illegitimate. Let me tell you something. In constitutional law, if you have the burden, you're going to lose. If you have the burden of proof in constitutional law, you are going to lose. Because when the court puts the burden on you, they can make that burden as high as they want. Say, you know what? You have some evidence, but not enough. You didn't meet your burden of proof. So here Harlan says the burden of proof is on the challenger, the person asserting the right to liberty of contract. Whereas excuse me, the majority puts the burden on the state. Okay. Harlan says, I'll go 2 seconds, Scotty, that it's plain that this law was established for health and safety, and we don't need to do pretext. We don't need to look behind the curtain. To use Delaney's framing of it, right? We're not going to look behind the curtain. We'll take the government's word for it that they're acting in good faith, right? We will not presume that New York acted in bad faith. That's what he says. The majority said, this is not your real reason. The court says we will not question this. Scotty?
My question is, I would have figured, reading like the first couple paragraphs of the case, that this was going to be an Article 1, Section 10 case, because it's just,
Contracts clause?
yeah, and I figured it'd be under a contract clause, because it's interfering with the baker's right to make contracts, and it's a state law, and the state's interfering with the right to make contracts. I just feel.
So I mean, we discussed the contracts clause briefly some time ago. The court has basically read the contract clause of the Constitution. And in theory, this doesn't infringe any contracts because this is a new wage, right? Every paycheck you get is really a different arrangement. And then going forward, if you can't make a bigger contract for more hours, it's not effective. So in effect, the contracts clause only applies to retroactive amendments of contracts, not to new contracts. Does that make sense? If the state had said, we are going to make you give back pay, for example, we're going to make you alter previous contracts, that may be problematic. But here they're saying going forward, any future labor arrangements have to comply with this law.
Even if you're employed for like a term of years, like you sign a 2-year contract with somebody for.
Most workers don't sign terms of years. That's very rare. Most people are at will. Terms of years don't really exist for employment unless you're in the military. Most people are at will. But in any event, the contracts clause has been basically read out of the Constitution, so it doesn't do much heavy lifting anymore. But good point. Any questions on Justice Harlan's dissent? On Harlan's dissent. All right, let's move on to Ollie, right? Justice Holmes was probably one of the most famous jurists of all time. He came from a very distinguished family. His father was a very prominent doctor in Boston. He was a member of this elite caste known as the Boston Brahmin, right? In the Indian caste system, like there's this renowned group of Boston elitists. He went to Harvard. He left his senior year to go fight in the Civil War. He was shot, I think, 3 times in the Civil War. So he had a very distinguished background. He then served as a judge in Massachusetts and was appointed to the Supreme Court. So one thing that you should know about Justice Holmes, and you'll read the Buck v. Bell case, I think, next week, is that he wasn't a progressive. He wasn't a liberal. He didn't particularly care for workers. In fact, he, in all respects, was a social Darwinist, which makes his dissent even more ironic. He believed in survival of the fittest in every regard. And indeed, he wrote the majority opinion in the eugenics case, which you'll read next week, where he said, we need to sterilize this woman because 3 generations of imbeciles are enough. We don't want these people reproducing more. So he was not a fan of the little guy, right? People often portray this dissent as Holmes saying, wow, we want to help the poor workers. We want to protect them from these unfair conditions. No, it's not true. What motivated Oliver Wendell Holmes Jr. was deference to power and deference to government. What motivated him was saying the government can do whatever they want if the majority supports it. If the majority of the government wants to sterilize this woman, then they can do it. If a majority of government wants to, tell bakers they can't work more hours than they want to, they can do it. So the unstated truth of Holmes' opinion is he didn't really care about the workers and anything else. All he cared about was deferring to the majority of government. And I think this somewhat comes through in the opinion. So he begins discussing, this case is decided on an economic theory, which a large part of this country does not entertain. He says, it's a very short opinion, I'll read portions of it. If it were a question whether I agreed with this theory, I would study it more. But it's to be my duty. Whether I think with it yes or no makes no difference. Okay? In one of the most well-stated lines in any dissent, he says, the 14th Amendment does not enact Mr. Herbert Spencer's social statics. What the heck does that mean? Herbert Spencer was a social Darwinist who helped push forward the idea of survival of the fittest in society. He actually used the phrase survival of the fittest before Darwin. Darwin got it from him. The idea was, in society, we should not be helping poor, weak people because it leads to breeding of people who pass on bad hereditary traits. That we should basically let the weak fall off the tree and take care of themselves or not and die. The irony of this is that Holmes emphatically agreed with this. He emphatically agreed with the social Darwinists. He was a eugenicist in all of its respects. And you'll see this next week in the case. But what he says is it's not for the courts. Okay? What he says is it's not for the courts to engage in this sort of act. He believes the states have a wide latitude, a virtually unlimited power to decide how to arrange the health, safety, welfare, and morals of their people. Okay? He did not believe that any law that garnered a majority support should be stopped by the courts. In fact, he announces that a case, the Massachusetts vaccination law. This was a case of Jacobson versus Massachusetts. So the facts of the case were like this. Today we think of the people who are anti-vaxxers as crazy, right? Vaccines are safe. These people are insane. That causes autism. It's not true. But the term the 19th century, vaccines were very dangerous. They were giving you a diluted form of the virus, and it could kill you, right? These were not safe things. So a number of people objected to taking these vaccinations. They didn't want them. And the Supreme Court held that they can be forced to take these vaccinations. So Holmes is basically saying, look, if we can force people to take a vaccination, then why can't the state require people to work only a certain number of hours? Keep in mind, this exact same case is cited next week in Buck v. Bell, where Holmes writes, if the state can make someone take a vaccination, then why can't the state cut their fallopian tubes? Right? He had this just very majoritarian notion of the law. So the gist of Holmes's dissent is he says that the Constitution is made for people of differing views. And it's not for the courts to interject themselves to second guess what the majority does. It's not for the court. Holmes famously said, one of my favorite quotes are his, if my fellow citizens want to go to hell, I will help them. It's my job. He firmly believed that whatever the majority wanted ought to happen. That was his firm, sincere, profound belief. Another judge who's been in the news recently, a judge named Robert Bork, who died about 3 years ago, he was President Reagan's nomination to the Supreme Court. He had a similar expression. He said, in wide areas of life, majorities are entitled to rule if they wish, simply because they're majorities. This is a notion of democracy as a liberty value to itself, that if the people vote for the representatives and they enact a law, then that's good enough. And I know this makes law students angry. How can it be these people are enacting laws they don't like? Well, the flip side is judges are issuing rulings that contradict what millions of people voted for. Law students love courts striking down laws, but they very seldom consider the fact that people voted for them and their representatives wanted them. And the text of the Constitution maybe doesn't really cut one way or the other in that way. Okay? But Holmes says this is a reasonable measure and it's unnecessary to even discuss it. We should be upheld. Okay. Most famous dissent ever. I think it's way overrated. I don't even think he didn't even put that much attention to it. He wrote it very quickly. But whatever. Made people happy. So question on the Holmes dissent. Question on, yeah.
When he was talking about economic theory, was he just talking about the right to contract solely?
He was discussing a form of laissez-faire capitalism, right? The idea of people can make their own contracts without government intervention. That's what he was discussing. He charged that the majority was basically using their own economic theories as a mode of constitutional interpretation. So whereas Justice Harlan accepted the idea that liberty of contract is protected by the Constitution, Justice Holmes said nothing. there's no liberty of contract at all. As a matter of history, he's probably wrong, but that's the theory that has not predominate, but most progressives would agree with.
So he doesn't believe in substance.
None at all.
So why isn't like the black spot case just like a huge counterexample to everything he believes in?
Oh, he would probably agree with the black spot case. He said, if my fellow citizens want to go to hell, help them get there. No, I mean, I'm not exact. I'm actually reading a book about the Buck Fidel case now called Imbeciles. It's a very good book if you want to read it. And it has a very good biography of Holmes. He firmly believed if the people wanted to pass a law saying you stone someone if they get a black slip of paper, he would have supported them. He would have held it. Go read his decision next week in Buck v. Bell. This is this forced sterilization case. And he says explicitly, if the majority want to do something, that's good enough for me.
Well, it does also seem to be like anti-constitutional to sort of have that opinion that the Supreme Court justice.
Why?
Because it's going against something that was also in the Constitution, which is the process.
Oh, excuse me. Where in the Constitution does it say? So John, okay, I'll show you the 14th Amendment. Right. So she got all the process she was due. They had Joseph Lochner to trial. The phrase substantive due process is not the Constitution. I think it can be derived from Magna Carta and other doctrines, but I mean, those words up there do not say, in any respect, that a person cannot be forced to work more than 60 hours. Those words do not say, in any respect, that a person's ovaries or tubes can't be cut. It doesn't say it. If you look at the text of the Constitution, it doesn't say it. It doesn't. I mean, there are cases and doctrines, but Holmes would say those cases were wrong.
Yeah, I just felt like this criticism not mean to be a criticism to look at. If you don't look at fairness, underlying the law.
He would say, and I mean, you can read this, the book's called Imbeciles, a very good book. I'm reading it now. The word fairness does not appear in the 14th Amendment. According to Holmes, all my role as a judge is to make sure that you would give a procedure. There's nothing but substance there. And indeed, that's a theory that prevailed until 1967 or so, when they decided that substantive due process was helpful for reproductive rights. It was jettisoned. So any questions on Lochner? So let's move forward, right? After Lochner. So this is often called the Lochner era, but I don't like that phrase because it wasn't really the Lochner era because the cases were all over the place. So you had one case called Mueller against Oregon, okay, which involved the Lace House Laundry. And the state of Oregon passed a law prohibiting women from working more than 10 hours a day. Now, this law should make you go, huh? Why do they say that women could not work more than 10 hours a day? Well, the argument was because they were too weak, that they couldn't handle it. I'm not joking. A Brandeis brief, right? Justice Louis Brandeis, famous justice, he submitted a brief to the court in this case. This 100-and-something page brief offering all this evidence about why women were so weak, and the state, through their police power, had the ability to protect them. I'm not making this up. He said that women who work too much, their uterus will fall out. I mean, there was such crap in the Brandeis brief. People extol the Brandeis brief, this awesome thing. It was full of crap. There's stuff that's like wrong. But he submitted this brief to the court, and you want to know what the court said? They upheld the law, saying, you know what? Women, the gentle race, right? These noble women, they can't be forced to work so many hours. That's just not fair. Again, no one was being forced to work that many hours. They can walk off the job they wanted, but they said it's unfair. By the way, who supported this law? Men. Why? Because they didn't have such limits. Baptists and bootleggers, right? You make it harder to employ women by capping their hours. There's not much of a mystery here. But again, the court upheld it, saying that there are physical differences between men and women, which justify this. Interestingly, there was a dissent by Justice Sutherland. Oh, I'm sorry, that came later. That's a different case involving women. Sorry, my mistake. But the court upheld this law. There was another case in 1923, Atkins versus Children's Hospital. Okay, there was a minimum wage law for women. Now, this law was invalidated. They said women are of equal bargaining power. If they want to negotiate a wage, they can negotiate their own wage. That this minimum hour law doesn't work. Okay. One other case I think I mentioned before, Buchanan against Worley. This was a case in Louisville, Kentucky, where Louisville segregated neighborhoods. Said, okay, this will be the black neighborhood, that'll be the white neighborhood. And it actually said a white person cannot sell their house to a black person and vice versa. The court actually invalidated that law, saying that it was a violation of the liberty of contract, that you can sell your property to whomever you wish, right? Interestingly, Justice Holmes wrote a dissent in that case, which he never published. Right? He actually withheld. Oh, no, did he dissent? Oh, God, I can't remember. There was another case where Holmes dissented, but he never published it. I can't remember if this was it. But Holmes did not like this decision either. I might be wrong with that one. Okay. But then came 1937, okay, when much of constitutional law changed. So the case was West Coast Hotel v. Parrish. This is actually a picture of the hotel. Washington State passed another minimum wage law for women. Wait a minute, didn't you say the court invalidated a minimum wage law for women? They passed it anyway. As this case was being argued, President Roosevelt announced his court packing scheme. And he said, you know, if the court keeps tracking down these progressive laws, I'm going to add another couple of justices. Now, again, I think I mentioned this last time. It probably didn't happen this way. But the conventional wisdom is Justice Roberts, not John Roberts, but Justice Owen Roberts changed his vote. And originally he voted to invalidate the Washington law, but he changed his vote to uphold the Washington law. That changed the course, and that effectively killed Lochner. It didn't quite, but this more or less did it. The court overturned Atkins versus Children's Hospital, and they said that we are not going to be looking at these sorts of economic freedom of contract arguments. Okay. In other words, the Great Depression and the current economic conditions are making us rethink our constitutional law. So, whereas perhaps the Lochner majority considered one school of economic thought free market economics, the West Coast Hotel Court considered another school of economics, Keynesianism. Keynesianism, right? The idea that you know government control will correct depressions. So, lest anyone tells you that the court doesn't consider economic theories, they're basically articulating the idea that, you know, well, maybe government interventions actually benefit, but in any event, it doesn't matter. We're not going to second guess the legislature. We're just not going to second guess that. But they articulate economic theory in their opinion. Okay. Interestingly, the West Coast Hotel dissent by Justice Sutherland, which is in your book, reads like a gender equality opinion. It reads like the VMI case, maybe, or the Craig v. Bourne case. It says that women are equal, that the difference of sex affords no reasonable ground for making a restriction applicable to wages. In other words, women can negotiate their own wages. They're smart enough to do so. Okay. Justice Sutherland also makes a point that sounds in originalism, the idea that the meaning of the Constitution does not change based on changing economic conditions. This was actually a theme of the New Deal. That because of these new economic conditions, we should read the Constitution differently. And Justice Sutherland's dissent rejected that. So the actual West Coast Hotel case wasn't particularly important on the facts, but it announced a formal repudiation of the idea that the court would stand in the way of these progressive laws. And this is when Franklin Roosevelt basically won his court packing scheme. Okay. Everyone okay with that? Everyone get West Coast Hotel. All right. So there's one more case which is mentioned almost in passing, but it's a fairly significant case. And the case is called United States versus Carolene Products. Now, this is a Commerce Clause case. And the facts of the case were like this. Does everyone know what filled milk is? Condensed milk? Okay. So historically, refrigeration has been very expensive. So the transport of milk is very costly. All right? The transport of milk is very costly. Condensed milk works by taking regular milk and extracting the dairy out of it and replacing it with vegetable oil. By doing so, you can actually put condensed milk into a can. I have a can here. So you actually put the condensed milk into a can. That way you can transport it without any sort of refrigeration. Who do you think feared these sorts of laws, Zach? Who do you think hated, condensed milk and was very afraid of it? Which ones? Dairy farmers, yeah. The dairy farmers absolutely hated condensed milk. You know what else they hated? Margarine. Because margarine does not get refrigerated the same way butter does. So what happened? Rent-seeking. These companies use the arm of the state, right? These companies use the arm of the state to get them banned. And the United States government, if you can believe it, enacted a federal ban on condensed milk. Why? Because they said it wasn't healthy for you, right? The irony is condensed milk is healthier for you than real milk. There's no cholesterol. It's actually better for you. Right? It's actually better for you. But there was one company called the Carolene Products Company in Illinois. Where have it? Have it up here. And the Carolene Products Company made a product called Milnot. It's actually still sold. Okay. What was Milnot? It was condensed milk. I actually have on eBay, from my possessions, a 1937 edition of a Carolene Products cookbook. And you can go visit it after class. And also I have an entire case of their milk. Okay? So, what happened? The owner of this place, I only have small pictures, was a guy named Charles Hauser. Okay? Charles Hauser made condensed milk, and he hated these state and federal laws prohibiting the transportation of filled milk. Okay? So what did he do? He deliberately tried to deliver milk across state lines. The family story is that he deliberately drove a truck from, I think, West Virginia to Ohio in order to trigger this federal ban. I actually spoke with not his grandson, but one of his nephews, and I spoke with his niece. They actually called me. It was kind of cool. I spoke with them. So that's a family story. It's not true. It didn't actually happen. But someone on his staff actually drove across state lines for the sole purpose of triggering this law. Why? He wanted to challenge the constitutionality of the Filled Milk Act. Okay? By the way, he was also something of a genius. So in order to also get around the rule, he built a factory on the state line between Missouri and Oklahoma. So there's actually a brass rail down the middle of the factory. And you can see there actually are car doors on both sides. So he would deliberately make the product on both sides of the factory and never ever cross state lines and ship this side to Oklahoma and this side to Missouri. And after the actual filled milk was made, nothing was allowed to cross this brass line in the middle. So this guy was a pretty intense guy. So he challenged this under the Commerce Clause and went to the Supreme Court. The Supreme Court upheld the conviction, right? And the actual decision itself wasn't complicated. By that point, we already had Wickard v. Filburn. Wickard was a couple years away, but we were about to have Wickard. He was clearly shipping this milk across state lines. The court found that was interstate commerce. Now, a funny footnote to this case is that shortly after the conviction became finalized, President Roosevelt actually commuted his sentence. He pardoned him, which is something kind of crazy, right? The federal government was just prosecuting this guy for violating this Filled Milk Act. And actually, it's a picture of President Roosevelt pardoning the guy. What makes this even more serious is that Franklin Roosevelt died about a month after issuing this pardon. So this was actually one of the last official acts of Franklin Roosevelt. Now, excuse me, why am I telling you this entire lengthy story? Why do we care about the Commerce Clause? There was a footnote in footnote 4. Okay, there was a footnote of Carolene Products. No, it's footnote 4 of Carolene Products. This is probably the most famous footnote in the history of the Supreme Court. Why is this footnote so important? I have it up here. You can read it online later or whenever. But what footnote 4 effectively says is we're going to apply different levels of scrutiny to different kinds of rights. The notion of modern day scrutiny was born in this footnote. Okay, so let me read you parts of it. He says there may be narrower scope of operation of the presumption of constitutionality when legislation appears on its face to be within a specific prohibition of the Constitution, such as the first 10 amendments, which are deemed specific when embraced in the 14th. So what he's effectively saying is when the government tries to infringe on a right that's in the Bill of Rights or the 14th Amendment, there's a narrow presumption of constitutionality, right? What does that mean? Courts are going to be skeptical. That means strict scrutiny. When there's a government action that violates a provision in the Constitution that's enumerated, that's listed, right? An enumerated right in the Bill of Rights, the courts are going to be skeptical. Okay? Okay? But the flip side to this, right? The flip side to this is that what happens if a right is not enumerated in the Constitution? Oh, like substantive due process. What happens if you have a right like the liberty of contract, which is nowhere written in the Constitution? For these sorts of rights, footnote 4 says, we give deference to the democratic branches. We give what became known as rational basis. What footnote 4 does is basically carve up the Constitution like a turkey on Thanksgiving, right? If it's an enumerated right, we give it this sort of strict scrutiny. If it's an unenumerated right, it gets rational basis. He didn't use those words, but that's the effect of what happened. This footnote was meant to bury the idea of substantive due process. But there's an exception to this. He says, what happens if certain government laws affect, quote, discrete and insular minorities? Discrete and insular minorities. Insular means like separate. They don't have access to the political process. For laws affecting discrete and insular minorities, you give heightened scrutiny as well. So he not only articulated a chopping up of the rights, but a political theory that the courts have a role of reinforcing the rights of certain discrete and insular minorities. Now, most people, when they say footnote 4, only remember the last part. They only know about the discrete and insular minorities part. Excuse me. But at the time, the essential part was the chopping up of the rights and saying we will no longer do this substantive due process business. We are not doing Lochner anymore. Lochner is gone. It's dead. We're going to bury it. Okay? So any other questions then on footnote 4? Okay, so what happened after footnote 4? In a series of cases, the court made clear that they will no longer scrutinize the liberty of contract. So one case called Williamson v. Lee Optical, I think I mentioned this last time, where I think Oklahoma passed a law saying only licensed ophthalmologists, doctors, can fit lenses onto frames. If you're an optician, you can't. Okay. You don't need to be a doctor to put lenses on frames. There's absolutely no reason why. There's none. But the court said, we are no longer in the business of second-guessing the legislature. We are going to defer to their judgment. The court says the day is gone when the court uses the due process clause to strike down state laws that may be inconsistent with the school of thought. This is Holmes's dissent prevailing, that we're not picking economic theories. So until the 1960s, the court made clear, unless this constitutional right is enumerated, it's written down in the Bill of Rights, we are going to defer to democracy. Again, this is Holmes, right? Unless there's something specific that tells us you can't do this, we're not going to interfere. All of that changed. Okay? All of that changed in the late 1960s with a case called Griswold against Connecticut, which held that the state cannot prohibit access to contraceptives. Griswold picked off exactly where Lochner left off. And you'll study Griswold for next class. All right, questions? No? All right, have a wonderful weekend. Thank you.
I got it.